Thank you. Good morning. Please be seated. This is the time set for argument in our number CV140698. Arana and Avalos versus Bowers. Each side will have 20 minutes in which to argue its position. The appellants may reserve a portion of that time for a rebuttal argument. Counsel, you need to keep track of that time for yourself. We have read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellants may proceed. Looks like you got 20 minutes and 1 second.
Great, thank you, Your Honors. Jules Grandjean for the appellants. Before I begin, I should let you know that I'm a little under the weather this morning, so I'll probably serve our purposes best by saving my voice for your for your questions. There are just 3 facts that I want to point out for the court before I take your questions. And all of those have been conceded by the appellee at both the trial level and at this level. The first is that the amended complaint is the same circumstances as the original complaint, arises from the same excuse me, occurrence. The second conceded fact is that the insurer received notice of that original complaint by May 20th of 2013. And the third conceded fact is that the insurer knew that the driver involved in that collision listed in the complaint was Amy Bowers. All of those facts were conceded by defendant appellee, and from what I can tell in their brief, none of those are being contested here at the appellate level either. So I don't think there's any way to properly apply Rule 15C without finding that the amended complaint properly relates back under the rule in Pardman versus Vickers. Excuse me. So I'll take your questions if you have them.
Well, counsel, the insurance company argues that there was 120 days from the date that the original complaint was filed for them to have notice of the change, correct?
I believe that is part of their argument, Your Honor, and I saw that on page 28 of their brief. How I noticed there's not one citation, legal citation for that position. It just happens to be their position, and I haven't been able to find any legal authority myself that supports that position or that reading.
Well, wasn't that the position that the trial court took, that regardless of when the complaint is filed under 4I, you have 120 days to amend it and correct the mistake with respect to the person who was notified who was listed as the defendant?
Your Honor, I don't believe that was what the trial court found. When I look at their ruling, it looks like their ruling was based on basically reading the facts different than what defendant even conceded about that State Farm didn't know it was Amy that was the driver, and that they didn't get notice within the meaning of Rule 15C. That's what I see in their order. And regardless if they did read it that way, if that is the reason, I'd say that's incorrect. There's no legal authority for that, and it really puts 2 different plaintiffs at odds. One who files a complaint earlier is barred from amending that complaint sooner than someone who files it later. And I think the plain language is meant to be read plainly, and also to be read to give everyone the same opportunity to amend a complaint.
But isn't the issue that we're looking at here is whether notice given in May was timely. And the insurance company says it had to be by a date in April. Isn't that the issue that's pretty squarely presented to us?
That seems to be their argument. Yes, Your Honor.
So if in this case, the original complaint had been filed against Harry, and the 120 days just ran and no extension was sought for service, and the action would have abated, correct?
It would have, or I don't know how the intricacies of the court's dismissal calendar would have worked it out, but yes,
So-
eventually.
So then, if you had just sought to amend the complaint and sent it and notified the insurance company in May, there wouldn't have been anything left for it to relate back to, would there?
I still think that there would have. We're only talking about Rule 15C here. That's
Right, but if the action had abated, was there anything left? Isn't it gone?
I think if the action abates before the statute of limitations period plus 120 days, it can still be fixed with Rule 15C.
So your argument is not dependent on the fact that you got an extension?
I don't think it is, no.
And you see the argument under 15C as relating back to a time within the statute of limitations, not to the complaint, based on the rule.
It relates back to the date of the filing of the complaint, if I'm not mistaken, Rule 15C. That's the way I understand it, is it's basically treated as that's the day that it was filed properly. It relates back to the day it was filed mistakenly.
So why didn't you only have 120 days from that date, if that's the date that you get the advantage of?
I'm sorry, from which date, Your Honor?
From the date of the filing of the complaint.
If you only had 120 days from the date of filing the complaint, one, that wouldn't square with the language of the law. And two, again, you've got an issue where the more diligent attorney who's filing a complaint before the statute of limitations runs gets barred from fixing his mistake sooner than the attorney who files the complaint later. In the same way, a defendant happens to receive a benefit, whereas another one doesn't. And I think just policy-wise, that doesn't really make a lot of sense. It's easier to read it as equal.
So if the complaint had been filed on day 2, the day after the accident, and you couldn't find Harry, but you'd have at least the next nearly 2 years to either do it or correct the mistake, or without even worrying about Rule 15C, wouldn't you?
That's right, yeah. Rule 15C is really there to help fix things if the statute is run.
Exactly.
So you have a chance to remedy that within the statute of limitations by bringing it again.
The absolute cutoff to give notice would be the 2 years plus the 120 days.
That's my understanding, yes, Your Honor.
So that anything after that doesn't relate back, and the statute then would bar it.
That's the way I would read that, yes.
Okay.
Well, if there are no other questions, I'll reserve the time in case there's anything additional.
Okay.
Thank you.
Then we're going to order you to go home, have a hot toddy, and get a nap. Okay?
Good morning, Your Honors. My name is Brett Donaldson. I represent Amy Bowers. I do not represent State Farm in this case. State Farm is not a party. I know there was a reference as State Farm being a party to this lawsuit. They are not.
I didn't think Harry existed.
And that would be my understanding, too, because in part of plaintiff's justification for what they were...
Well, you must represent someone if someone doesn't exist.
I represent Amy Bowers.
Yeah, okay.
Harry Bowers is apparent fiction, and that was one of the things that the trial court in this case realized later on when we filed our motion to dismiss an alternative motion for summary judgment was in the plaintiff's counsel's previous filings requesting an extension of time, they avowed that they were trying to serve Harry Bowers and they couldn't get him served his last known address. They've never provided any evidence of that, so we don't even know if Harry Bowers is a real person.
Well,
and if-
clearly there was a real mistake here. I mean, let's kind of cut to the bottom line. There's correspondence back in 2011 between the person you really don't represent, but apparently is the carrier, and the counsel for the plaintiff here, in which there was information exchange. And in fact, the driver was identified as Amy. And for reasons that perhaps just a complete use, I think a passive voice, mistakes happen, or mistakes were made. Harry is named instead of Ms. Bowers, and that continued misnaming kind of continues on. Why isn't that a mistake that's cognizable under Rule 15C?
Thank you, Your Honor, for that statement. The reason why it's not a mistake is because of the case law that has interpreted the mistakes that plaintiff's counsel has pointed out in his case. For example, plaintiff's counsel had relied on Timon versus Hintz as providing support for their position. In Timon, the issue was whether or not the newly served defendant knew or should have known that but for the mistake, a proper person would have been identified. It was not an issue about, as the courts have asked counsel here today, whether or not the party was actually served and were they served with a complaint within the 120 days as required under the
Let's stay with the
rules.
mistake point before we get to the
Sure.
time, okay?
And so in that case, where they analyzed the mistake, the court clearly said what is not a mistake. And the court indicated that we know it is not a mistake if you make a deliberate decision and identify the wrong person. Here, Harry Bowers was presumably deliberately identified. He was identified in the original complaint. He was also identified in the amended complaint in the caption. Then he was identified as the spouse of the fictitiously named Amy Bowers, which would have been Jane Doe Bowers.
Is there anything
Sure.
in the record that demonstrates how, we know there was an accident, and that apparently Amy provided some information. The plaintiffs then saw a lawyer and contact was made. How Amy morphed into Harry. And the only thing I can sense is the handwriting, and someone thought maybe, and then it just got perpetuated.
Okay.
So as a mistake.
Right. And the burden of proof, again, falls on the plaintiff to prove that mistake by way of convincing evidence. Here we have a female that was at the scene, yet they're identifying a male as Harry Bowers.
I'm assuming someone in the lawyer's office made a mistake. It wasn't Amy did make the mistake, and I don't think the plaintiffs made the mistake.
Well, I think that all mistakes, just by saying it was a mistake, you don't meet your burden of proof. Otherwise, anything, as long as you say it's a mistake and it's the wrong person, is going to prevail regarding the portion that discusses mistakes. But the court also said it is not a mistake to replace fictitious parties. Here, what did they do? They replaced the fictitious party, i.e., Jane Doe Bowers. They named Harry Bowers and identified Jane Doe Bowers. That can be considered a fictitious party because you don't know if he's married or not, just like you don't know if the ABC corporations are involved or not.
Are you talking about the amended complaint?
Yes,
Well,
the original
Original one.
the original complaint identified Harry Bowers and Jane Doe Bowers.
Well, the amended complaint talks very specifically about Amy Bowers in the text.
In the text, that's correct.
Right.
So they would have amended, but they also had Harry Bowers named still in the complaint as the amended complaint as the husband
Doesn't this
of Amy
suggest a
Bowers.
major bunch of mistakes? I mean, it's just, bless the plaintiff's counsel, but doesn't this all suggest just one mistake after another in trying to figure out and do this correctly? And,
Well,
and we don't like these type of mistakes, but that's just what happened here.
Well, in one part, you have to ask, was it just a mistake, or was the lawyers not doing their due diligence in identifying proper parties? And do the courts essentially allow you not to do due diligence in identifying the proper parties and say, you're excused from doing that? We know on the facts they knew who Amy Bowers was. They also knew that long before the complaint was filed. They knew that after the complaint was filed. And then during the time period that they moved to extend the 120 days, they tried to blame it on someone else other than themselves. And when the trial judge realized that that was the case, the trial judge said, wait a minute, you're asking for sanctions against these parties because you did not comply with 120 days. Why? Explain to us why I should not be able, under the case law, to say you did not provide me accurate information to allow me to rule on the extension. And lack of knowledge, the same case that they cited, Timon versus Hance, lack of knowledge as to the appropriate defendant, as opposed to a mistaken belief that a named defendant is liable, does not constitute a Rule 15c2 mistake. Those are what the courts found or what the court found in Timon versus Hance. Now, going back to the 120 days, and I'll just address one quick issue that Plaintiff's counsel said at the end, where they've changed their position twice. Earlier, they said, well, you don't have to serve somebody in 2 years plus 120 days. You can carry it out till the statute of limitations runs. Here's 2 years, and then serve after 120 days. You're correct. You can go ahead. If the statute runs in 2 years, you decide to file your complaint on the very last day that the statute runs. You have 120 days to serve that party from that date, and if you need to amend the complaint to have it relate back to the original complaint that you filed, you must do it within that 120 days. The rule clearly says that. Plaintiff's counsel argued to the court, trial court, and to this court that, no, because that would punish the person who's diligent and files her lawsuit 1 year after the event takes place. So therefore, they have an additional year remaining to fill in the 2-year statute of limitations plus 120 days. So we actually have 365 days plus 120 days to serve our complaint. And that is clearly not the law. And he says nobody's citing to anything. Well, the rules themselves tell you that's not the law, because carry it out to logical conclusion,
Well,
the minor child...
It seems that at least Rule 15C says notice has to be given within 120 days, presumably after the filing, if you're going to correct the name of the defendant or the correct defendant, as opposed to service.
Well, we do...
So that if, in fact, there is notice, and if the notice to State Farm was timely, then you still get to amend. You could then get to serve.
Well, your service...
In a reasonable fashion.
Your service of a lawsuit has to occur within 120 days. Your fallback argument is saying, well, you know, we attempted to serve them, but we could not serve them within the 120 days. So judges, you should find that they still had notice, even though we didn't comply with service, and we're asking you to set aside that failure to serve the party within 120 days and say there was still no harm to them because they nevertheless had notice of it. But you still, in order for a case to be prosecuted and not be dismissed, you have to prove that the party was served within 120 days. In this case, they failed to do it. Following his logical conclusion to the utmost extent, the minor child in this case, according to their argument and to the judge, would be, we filed the lawsuit on behalf of the minor. We didn't have to serve the defendant until the minor was the age of majority plus 120 days. And that's ridiculous because we know we get from the courts, what do we get from the courts? Administration. You get a notice of intent to dismiss for lack of service. In this case, it was filed on March 9th, 2013, telling Plaintiffs' Counsel, you don't serve, provide proof of service, the case is going to be dismissed because it calculated the date of the complaint was 12/5/12, 120 days from that, 4/4/13. And at no time did they provide any notice to Amy Bowers prior to that time expiring that they were intending to file a lawsuit. A lot of lawsuits aren't filed after a motor vehicle accident occurs.
Well, at least because the court dismissed the action of the child and the statute hasn't run on the child, the still has the ability
right,
to file a lawsuit.
And I present that to the court. The court very well asked me, Mr. Donaldson, if I get rid of the parents' claims, does the child claim still last? Because they say the child's a minor and he can wait for 20 or another 10 years to serve the defendant. And I said, no, you go back to the lawsuit was never served on the proper party. It gets dismissed. Now, the child can go ahead and turn around and file the lawsuit because the child's statute of limitation has not run. But the parent's statute of limitation certainly ran. And the court, under the case of I think it was, I'll find it here, the court had the power to go ahead and go back, as the court indicated to counsel when he was up here. Doesn't your case rely on whether or not the court was able to extend the 120 days and did in fact extend the 120 days? And the answer is yes, his case had to, because otherwise, if you didn't have the 120 days, the case gets dismissed. And so the court, relying on the information that it had at the time, ex parte communication, meaning a pleading that was filed solely without any input or delivery to the Amy Bowers or counsel or State Farm, went ahead and moved the court to extend the deadline to provide service. The court granted it on 2 occasions, and then when the court realized all the facts, the court says, no, that is revoked. And that is certainly within the power of the trial court to go ahead and do that under the law. And there was nothing that prevented the court from doing that. I think that the court's minute entry explained that and the basis for it.
So your position is, once the complaint was filed, they had 120 days to serve, regardless of notice. And even though, and when they served the wrong person, Harry, by publication, and provided notice to State Farm of the summons and complaint, then it doesn't relate back because it's otherwise time barred. That's your position.
For a lawsuit to be enacted against a party, you must file the complaint and you must serve that party with the complaint within the time period allowable under the rules. The notice issue comes up as if you failed to do that and you're trying to get relief under Rule 15C and saying, Judge, let's revert back and here's my explanation. We didn't serve Amy Bowers because we had no knowledge who Amy Bowers was. We didn't know, we couldn't have known, and we were diligent in trying to identify who Amy Bowers was. We failed to do that, so we're asking you to provide us relief, either to extend the deadlines and or to provide service, or because we failed to do that and they moved to dismiss, we're asking you to provide us relief. But you still got to prove those elements under the rules. And Rule 15C says you got to file the complaint. The amended complaint has to be filed within a period of time. The period of time is within the time for the statute of limitations plus 120 days after that.
I'm sorry, but I've looked at the rule and I've read the rule a dozen times since
it isn't the easiest rule.
I don't think it's unclear at all. It says within the period provided by law for commencing the action against the party to be brought in by amendment, plus the period provided by Rule 4I. And then it talks about notice. So as long as there's notice within the 2 years plus 120, that's notice. That it has nothing, it does not require service. It talks about notice.
Under Rule 15C, I would say it talks about notice, but you get to that issue of notice after a party's been served and the party says, I wasn't served timely. And then you go back to whether and if you weren't served timely within the rules, as you stated, you'd have from the date you file your complaint.
That would render 15C almost meaningless. Almost irrelevant. Why would we go to all this effort in all these cases to talk about mistake when it would hardly relate back, because we'd go back to, well, you didn't serve the proper defendant within 120 days. It's like an extreme gotcha.
It's not. It's not. There's occasions where you, but for your own diligence, were unable to identify this individual through certain means and attempts. You took diligent steps. When you went to extend the 120 days, requesting relief from the court, you were upfront with the court and not putting the blame on somebody else. And the court has to find good cause in order to grant the extension. In this case, the court determined that there was not good cause by revoking the 120 days that it extended on 2 occasions. And the court has that power. The plaintiff in this case, has to show that the court does not have that power to do that. And the court, the trial court has that power. The trial court is one that is hearing this and going through this process. Rule 15C, again, is when you're asking the court for relief to relate something back. You still have to comply with the rules of service. A lawsuit does not become effective because you go ahead and say, well, they had knowledge of it. Does that? I don't think the court takes that position. This court takes that position.
The court had not revoked. Let me ask you this way: sure. If the court had been unpersuaded and had not then revoked its determination to extend the 120-day abatement, the 120-day period, that argument, you couldn't make that argument then. I mean,
what argument?
Well, forgive me, that wasn't very clear. If the court had not revoked 120 days, its decision to extend it.
Correct.
Then we would just be dealing with a straight relation back situation, correct?
No, not correct. You would still have the issue of non-service being done. So if the court did not extend, let's say the court did not extend, as the court brought up.
Let's say the court decided it was not going to go back and revoke its decision to extend.
Then you now have the same position that plaintiff's counsel is in this case, in arguing that it should relate back because there was a mistake that was made and provide that burden of proof.
So much of your argument rests on the court's decision to revoke its prior decision to extend the 120-day service period.
Well, that's one portion of the argument. You have to, in order for the plaintiff to even get to argue the mistake, he's got to say, I had the year or whatever to go ahead and get my extension to finally identify Amy Bowers in the body of a complaint.
Doesn't that go back to my concept that once they file the complaint, and 120 days went by, if they didn't get an extension, the action abated.
That would be correct. And so the court then would say, we need to look at, is there good cause to go ahead and do the 120-day extension? The first one was, well, Mr. Bowers moved. Harry Bowers moved. Where's the evidence that Harry Bowers exists and that he moved? And that's where we were bringing up then when we finally realized what was going on and the judge realized what was going on. That's why the judge says, no, that 120 days for both those have been revoked because essentially the judge felt like the court was misled.
So you would say that because the extension should not have been granted and the court determined that essentially in May, when the insurance company was made aware of the Amy Bowers claim, that the action had already abated.
That is correct. That is correct. The court had...
So it couldn't relate back.
It could not relate back. And then
The case no longer existed.
That was the point I was trying, I'm sorry, I was kind of inartful. But
That's
that was
right,
the point
Your
I was
Honor.
trying to ask you about.
Right.
Yeah,
and-
we're all of us trying to make sure we understand the importance to each of your arguments of how the court viewed after the fact the extensions that it had granted previously.
That's right. And during that time period, again, they're trying to serve somebody by publication on 2 occasions, and the court found that the court did not feel as though it was told correct information that at the time it would have had to have relied on in order to find good cause. And the courts are able to go back and look at the record and say, no, had I known this, you would have never got an extension. But then you go into, was it an actual mistake? And you analyze a case law that says what clearly is not a mistake. You identified a fictitious spouse. You then, did that. I know my time has expired.
Your time's
Your
up,
Honor.
but I really would like to ask you this again, because this was Judge Norris's question, and I think it's the most pertinent one we have here.
Well, thank you.
The middle part of 15C says, could be read, and it probably its plainest meaning might be, they had 2 years plus 120 days to identify Amy Bowers and to let the insurance company know that Amy Bowers was the real person that they were bringing their claim against.
Well, I think they have that
The date of
time
the accident.
from, right, because your day of the accident is the time that your statute of limitations starts to run, and they never did that within that time period.
But they did within 2 years plus 120, didn't they? In May?
Oh, if we look,
I thought you had acknowledged that what you got in May.
the statute of limitations ran on January 25th, 2013.
Right.
Okay? The original complaint was filed December
Get the
5th,
complaint.
2012.
So I'm talking about 2 years from the original accident.
Right?
Plus 120.
Then go another 120.
Okay,
talking
so the service of the original complaint on 12/5/12 had to be served by April 4th, 2015. That included the 120 days. The notice was in May.
Okay, thank you, counsel.
Thank you. That they argued was in May. That plaintiff's counsel argued, and as the court was bringing up, was in May.
I'll try and just address real briefly what I think you're interested in, which is this issue of abatement of the original complaint and service and so forth. And if there is a true mistake that is made, of course a case is going to abate. You can't get, if you have a typographical error in the complaint, you can't get service on this person who doesn't exist. Of course that will happen, and Rule 15C is rendered pretty much meaningless if that's the case, if we start talking about service issues and so forth. And that's not what the trial court decided in its minute entry. It stated that its decision more or less had the same effect as if it had done that to begin with. But what it decided was Rule 15C doesn't apply here, and it decided that for the wrong reasons. And all we're here talking about today is Rule 15C and whether it applies. That's the only issue here. We can talk theoretically about service issues on minors and so forth, and if we were to venture into that, that may be correct, that, yeah, you do still need to, if you're going to file a complaint for a minor before he's 18, you still need to serve and so forth within 120 days. Yes, but that's not the issue here. The issue here is whether Rule 15C applies, where there's a typographical error made, and they conceded that they got notice within the statute of limitations period plus 120 days, and they knew that, but for us making a mistake, it would have been Amy's name, it would have been printed on the complaint rather than Harry's. I mean, it's really that simple. And I think it's getting confused quite a bit, talking about how service would interplay with these issues and so on and so forth. None of those issues have ever been discussed in the cases that look at Rule 15C in terms of whether or not they want to apply that Rule 15C to a mistaken complaint or not. They don't examine, well, when was service made in X, Y, and Z. It's simple. 2 years plus 120 days. Did they get notice of the action and know that, but for an error, it would have been printed differently?
But now, the notice that you gave in May of 2013 was notice to the insurance company of the action you filed against Harry Bowers.
That's correct.
And so the notice that's given under Rule 15C doesn't have to be notice about the new party?
Absolutely not, and that's why the third prong is there of under Parkman interpreting 15C says, but for error, they would know. They know, or they should know that, but for an error, this would be printed differently or would look differently, and they did know that because they knew Amy was the driver May 20th and even before. Thank you for your time. If there are no more questions.
Thank you, counsel. Hope you feel better. Thank you both for your arguments. We'll take the matter under advisement. We'll issue our decision in due course.
And before we leave, we'd say we're sorry for the loss of Bill Bagley. He was a wonderful advocate and had appeared in front of me just a year ago, and his loss is a loss to our legal community. Thank you.
We'll be at recess.